Good evening, this is John Milburn for Laws 12067. This is environmental law, and we've made it. We're in week 12 of term 3, 2019. So thank you all for your participation in this unit. I've really appreciated it, and I appreciate those who are joining me for the live session for your attendance this evening. So before I start to record, before I start to deal with any issues, are there any questions, comments, anything that you need to discuss particularly? All right, and I see Karen, there's a few storms around, and there may be from this end as well. All right, well, let's start with something a little different. I want to know whether you've been able to find information on Fraser Coast Regional Council and Byrne Brothers, and if you have, where you sourced that information. Any thoughts? And you might say Moodle, which would be a reasonable answer. But I'm interested in whether you found anywhere else to source the material. A few typing, I think. Court website, haven't come across it yet. Thank you, Emma. So we'll have a look at that first up. Indeed, the answer I was looking for is the court's website. And this is particularly useful for you to keep as a resource in mind for a whole range of reasons. One of them is particularly in relation to Byrne Brothers and Fraser Coast. But let's share the screen. I'll attempt to do this on my little screen here. And if I drop out, please hold on and I'll rejoin the session. And hopefully the recording will continue. So let's share the screen now, and my attempt, I'm not sure if this will be successful, my attempt will be to find the web page. Let's see how we go. So with any luck, you're now looking at the Queensland Courts home page. Is that what you're seeing? Karen, Emma? Yes, good. All right. So if you're not familiar with this web page, I'd urge you to become familiar. It's fantastic for a whole range of different reasons. And one of them is that it has the daily law lists, so you can see what's happening around the state. It has some excellent material in relation to domestic and family violence. The interest calculator is particularly relevant for those of you that want to know something more about the calculation of interest in a damages claim, and something that litigators need to use on a regular basis. Wills and probate deals with probate applications. And then there's, of course, something you're probably very familiar with, the section that deals with decisions and findings of Queensland courts generally. The part that I want to highlight tonight is that part that deals with search civil files. Now, if you've, if you've got access to court's webpage, you might want to undertake your own search, but otherwise feel free to follow what I'm doing. If we click on search civil files, you'll see that there are a number of ways that you can access civil files that are currently before the courts. And the one that I'd recommend for the purpose of determining something about Fraser Coast Regional Council and Byrne Brothers is the party search, the eCourts facility. And you'll see there, and hopefully it's coming up on the screen now, the party search. And you can search matters by a whole range of different methodology, but you'll see that I've already pre-populated this. If you go to party details, /company name, I've just simply inserted Fraser Coast as the first party. Then for the second party, Byrne Brothers. If we then search using those keywords, we come up with some information about the case, which is highlighted in the study guide, Fraser Coast Regional Council against Byrne Brothers Pty Ltd. And what's interesting is that it has the actual documentation relevant to the case. So it's a little like the material that we looked at last week in relation to our highlighted case. And again, you have an opportunity here to look at the specific details. It's a little slow on coming up, but I have the file summary elsewhere. I'm going to attempt to switch screens. Hopefully now you're looking at what it is that I was looking for? Does it come up with the file summary and a whole list of documents and events? Is that what you're seeing? All right. You'll see here that the parties were represented by McCullough Robertson for Byrne Brothers and Connor O'Meara for Fraser Coast Regional Council. It's useful because it puts all of what we've learned about the Planning and Environment Court into some practical reality. It shows you the documents, the court dates, the events as they're described, and you'll see that it includes issues of mentions, adjournments, applications, ADR processes, etc. It identifies the name of the judge, or in the case of certain matters, the registrar of the Planning and Environment Court. And you'll notice that each one of the judges has the suffix DCJ. And of course, that stands for District Court Judge, in that every one of the judges in the Planning and Environment Court is constituted by a practicing judge of the District Court. So, as it were, the judges change hats depending on whether they're sitting in the District Court or the Planning and Environment Court. But from a physical perspective, it's usually the same courthouse in the regional areas, or in Brisbane, it'll be in the those courts that are dedicated to planning and environment matters. So below the events, which has some of the detail about what happened, you'll see as a very valuable resource the actual documents that were filed in the proceedings. So in this case, if you're studying the matter and trying to get a feel for what happened in the case, I would recommend that you look at some of the key documents, such as the originating application, some of the key affidavits. And you'll see that some are quite lengthy. One is 164 pages, for example. And some of the other material, particularly orders. You'll see, for example, item number 24 is an order made by His Honour Judge Everson, and that was on the 8th of December 2014. So a valuable resource. I do believe that I've reproduced some of those resources in your study guide, but if you've got some time, and I know time is very limited, but even beyond this unit, I'd recommend that you have a look around the Queensland Court's webpage, and in particular, have a look at the file summary. Now, the summaries that I've identified here, which provide a lot of source documentation, are provided in the Planning and Environment Court arena. Don't expect to get anything like that level of detail and access to the original documents in other areas. But you see, environmental law, both at a state level, as we're looking at tonight, and a federal level, as we looked at last week in Booth and Bosworth, are designed to be available to the public in an extended way, because we're not dealing with just a dispute between individuals. We're dealing with larger issues here involving the community, the nation, and if we can be really broad, international factors as well. So I'll stop the share now, and if you haven't yet attempted to look at the court's webpage and find those details, please do so. It can be a valuable resource. Now let's have a little think about what actually happened in Byrne Brothers, Fraser Coast and Byrne Brothers. So this was a Planning and Environment Court case. And can anyone tell me, basically, in a word or two, what this case was all about? Are there any key words that come to mind if you've looked at it? Just to keep you moving on the spot. Any thoughts?
About, the words escape me, redesignating land use.
Yes, material change of use.
Thank you.
Yep. So there was that aspect of it, but probably even more relevant, yes, Emma says, breach of permit condition. That's right. And it related to enforcement proceedings. Now, the reason I've highlighted this is, firstly, you've got access to all of the material as it was in the actual case. The second is that it provides a good overview of how the Planning and Environment Court undertakes certain aspects of work. And and the next aspect is it's consistent with what we looked at last week in Booth and Bosworth at a federal level, in that now we're looking at compliance issues and enforcement of matters in the Planning and Environment Court. So when you're reading through the material, pay particular attention to the fact that the council was seeking an enforcement order pursuant to Section 601 of the now repealed Sustainable Planning Act. So it's a little bit like Booth and Bosworth in that we were looking to enforce something, but we were doing so from the perspective of a community litigant last week at the Commonwealth level. Now we're looking at a different type of enforcement in a different court, this time from the perspective of a council, and we're looking at it at a state level, looking at state legislation rather than the EPBCA, as was the case here last week. So in Fraser Coast Regional Council and Byrne Brothers, you'll see that what the council was attempting to do was use the court process in order to stop the respondent, Byrne Brothers, from doing something. And what were they trying to do? They were trying to stop Byrne Brothers from carrying out assessable development. And the assessable development related to a material change of use for extractive industry. The idea was that they should be stopped from extracting using the site for extractive industry purposes because, as Emma pointed out, they'd failed to comply with the condition of the development permit. So it highlights the fact that in relation to real estate, it can change use. It may be that there's a certain use, it may be there's a material change, and conditions might be imposed on that. So what happened in Byrne Brothers? The landowner failed to comply with the condition of the development permit for the material change of use for the extractive industry. And council imposed an obligation on the landowner to basically construct a bitumen road. That was the condition. Pretty simple, really. But it got a bit complicated because the road that was constructed was not yet on maintenance and the road didn't meet council requirements. And the council said it presents a risk to road users. Now, when we talk about on maintenance, we're really talking about when the council, when the government takes over control of it. So it was at that stage where the landowner was still responsible for the quality of the road. And the landowner, of course, had commenced using the land for extractive purposes. And in order to comply with the conditions, the court was asked to stop certain things and have the landowner undertake certain works to do other things to regulate the situation. Now, of course, reading between the lines, you'd imagine that there were multiple discussions behind the scenes. There were attempts by the council to enforce by other means through notices, discussions, fines, whatever it might be. But ultimately, after attempting administrative and cooperative action, the council saw fit to seek this enforcement order in the way it did. Now, of course, as we've discussed, councils and regulators can consider a whole range of remedies. So for examination purposes, if you're looking at issues to do with enforcement from the perspective of a council or a regulator generally, you need to consider a range of options. They might be administrative remedies or they might be court remedies. And the court remedy in this case was civil, but it's quasi-criminal because in many instances of enforcement, courts do have a power to impose penalty units. Alternatively, on some occasions, councils can seek good old-fashioned straight-out criminal prosecution. It's not generally so much councils that do that, but other enforcement agencies, such as the Environmental Protection Agency. So you can see the difference now. When you're looking at a matter, it's not just a matter of, from the perspective of a regulator, it's not just a matter of saying, well, the regulator can take court action and prosecute. For the purposes of an assessment, you need to be far more specific. You need to go into the litigation and non-litigation options. If it's litigation, you need to identify criminal, civil, what court, is it state, is it federal, what court do we pursue the matter in? And then you might want to consider some public policy considerations. So as far as the council is concerned, administrative orders are good because they're available as an out-of-court remedy, generally much cheaper, but not necessarily the best from a political perspective, because sometimes regulators are open to the allegation that they've gone soft and they're not prosecuting when they should be tough and prosecute. So the political side of things comes into it as well. So administrative orders might be show cause notices or enforcement orders. They're available as out of court remedies. However, sometimes in order to obtain a court enforcement order, action needs to be taken. And generally, that's either an injunction or a declaration, and that would be through the Planning and Environment Court. So I take it you know what I mean by an injunction, and you know what I mean by a declaration. Are those remedies equitable or legal or both? Can they be either or? Injunctions and declarations. Any thoughts? Looking for answers? Equity first for injunction, says Sarah. I agree. And I'll say that generally speaking, essentially declarations are also equitable. So as opposed to legal remedies, which really, when you're thinking about legal remedies, think in terms of damages. Overwhelmingly, that's the most common form of legal remedy. So when the council seeks an injunction or a declaration through the Planning and Environment Court, there are other issues. Standing would normally be the first thing that you consider, but standing's not an issue here, is it? It's pretty obvious that the council, having imposed the conditions, has the right to seek to enforce them. So yes, you might tick it off as on your checklist, but standing's not an issue in reality. Now, in this scenario of trying to enforce the compliance, are we involved in a merits review? Because you've heard me say in the Planning and Environment Court, most of the work is undertaken by way of merits reviews. So is this a merits review? Sarah says no. Good on you for getting in first and quickly, Sarah. Any other votes? Yes or no? Is the council seeking an order by way of enforcement, which would either be a declaration or an injunction, a merits review? We've got one vote. Any others? We're getting some votes now. Karen, no. Andrew, no. And I agree with the three of you. Thank you for voting on that. It's not a merits review. So the purpose of asking you that specific question is, before the take-home paper, I want you to be acutely aware of what is a merits review, when is a merits review undertaken, typically in the state jurisdiction, what court deals with merits reviews, and why does it differ from other matters such as enforcement hearings. If you look at most of the cases, now what was the case we did this year? It wasn't Predator John, was it? But you know, when the original case that I provided you, I've forgotten the name, sorry, Lamantina, Lamison, whatever it was, that was a merits review. And most of the courts in the P&E court are merits review, but not this one. So the court is not empowered to simply set aside a decision of the council and replace it with its own, as would be the case here. So it's not an issue of the court saying, well, we didn't think that condition was appropriate. We're kind of past that. And an authority for that proposition that this is not a merits review is another case involving the Fraser Coast Regional Council. It's Fraser Coast Regional Council against Walter Elliott Holdings, Pty Ltd. The citation 2016 QCA 19. Have a look at paragraph 40 of that case. So the civil law that we're dealing with here incorporates alternate dispute resolution, and you can see how that was incorporated because there's reference to the Planning and Environment Court registrar, which is usually a flag to say it's an ADR process. So where there's a criminal prosecution, there's a higher onus, which is beyond reasonable doubt. So The laws and planning policy and cases that may be relevant depend on timing is another aspect as well. So of course, in this instance, the facts as presented predate the introduction of the Planning Act to 2016. So therefore the court will hear the matter based on the Sustainable Planning Act of 2009, even though when the matter was determined, the Planning Act was enforced. In other words, you need to consider the question from the perspective of what was the law at the appropriate time. And if nothing is said, you might state in the answer to your assessment question, I'm assuming that we're talking about now, therefore I've answered the law based on the Planning Act. If the matter was predated the introduction of the Planning Act, then I would have answered based on the Sustainable Planning Act. That's the sort of thing you could consider. You could even drop that sort of thing into a footnote, so it's not affecting your word count too much. So if you were looking at this case, for example, from the perspective of the Sustainable Planning Act, and you were looking at issues around enforcement, here are some of the key sections of that Act that you'd want to consider. Section 578, which deals with carrying out accessible development without a permit. 580, which deals with the landowner not being under an obligation not to contravene a development approval, including any condition. 588, which deals with giving show cause notices, which is something that should be done before the matter proceeds to court, giving the other party a chance to show cause why the enforcement notice should not be given, essentially. Section 590, it deals with giving the first section was 578, Sarah. So 578, carrying out accessible development. 580, 588, 590, giving the enforcement notice. 594, which deals with a person who's given an enforcement notice must comply, and there are penalty units for failing to do so. Then there's section 601, which is key to this instance, which provides the council may apply to the Planning and Environment Court for the enforcement order to cease, which is essentially the injunction. Section 603, which provides that the court has power to make the interim order. 604, the court has power to make the enforcement order. And 610, proceedings must be brought within 1 year of the commission or 6 months of coming to the council's knowledge. So a little trick there. Again, you have to look at the dates carefully, and if there are no dates specified, then you may have to make a statement by way of an assumption that it is within time, because you've only got 1 year or 6 months, as the case may be, under that section 610. Now, apart from that, in this case, the Local Government Act was relevant. Section 138 provides that the council has power to issue a remedial notice. Then if you're looking at it from the perspective of the Planning Act, if we're looking ahead, then the relevant part, the relevant area of the Act that would be most relevant is Chapter 5 of the Planning Act. So that would be relevant to this case, and it's the chapter that deals with offences and enforcement. So it provides for a range of offences, including development offences, with emphasis on prevention or remedy of the offences. In other words, it's built into the statute to say, we really want to prevent any damage before it happens, hence the precautionary principle. But if the damage does occur, our main emphasis is not so much on punishing, but we want to remedy the effects of the offence. So that's the main emphasis. And that's probably a good reason why, as council, you'd attempt all these other options before you consider proceedings of that nature. So Lois said, what was the first act we said? The first act was the Sustainable Planning Act 2009, which was sections 578, 580, etc. And then I mentioned the Local Government Act 2009, section 138. And now we're on to the Planning Act 2016, and in particular, Chapter 5. Now within Chapter 5, Part 2 creates the development offences. Part 3 deals with the giving of notices from the enforcement authority requiring a person to refrain from committing a development offence or to remedy the effects of the development offence. Then we're looking at Part 4, which talks about proceedings potentially in the Magistrates' Court for development offences and other offences. And then we can go to Part 6 through to 8 inclusive, which talk about inspectors and their power of enforcement and related matters. Part 9 deals with miscellaneous provisions about offences and enforcement. Now, what's interesting in that is that I've mentioned this case was in the Planning and Environment Court, but those of you listening carefully, and I'm sure you all were, heard me say that Part 4 of Chapter 5 of the Planning Act is all about proceedings in the Magistrates' Court. Now, the difference here is that the Magistrates' Court is primarily the court, at least at first instance, where development offences are prosecuted and other offences against the Act are dealt with. So consider Part 4 primarily in relation to issues of, well, straight out criminality. And those commence in the Magistrates' Court and often dealt with entirely in the Magistrates' Court. So if this matter was dealt with now, the Council would likely rely on Section 164 of the Planning Act. That section says quite simply a person must not contravene a development approval. And Section 164 goes on to provide for penalty provisions. The maximum penalty, 4,500 penalty units, so potentially very serious indeed. But before proceeding, under the Planning Act, the Council should ensure that the alleged development offence was not exempted. So you need to look at the exempting provisions, have a look at Chapter 5, Part 2, or Chapter 7, Part 1 of the Planning Act. For example, an exemption applies if an emergency exists because of safety concerns, which is Section 166. Now, you should also advise, if you're involved in advising the Council, you'd advise the Council to issue a show cause notice. You'd refer to Section 167 of the Planning Act, and the Council should take matters to the next step by issuing the enforcement notice on that basis if it reasonably believes that a person has committed or is committing the development offence. Remember, of course, that time periods might apply. We'll get to that shortly. Now, the enforcement notice under the Planning Act would allow for a requirement for a person to refrain from committing the offence or a requirement that they remedy the effect. And have a look at Section 168 and subsection 3 and subsection 5. So what else would you consider advising the Council in these circumstances under the Planning Act? Well, you'd ask the Council to advise the recipient that they may appeal the decision and have a look at Section 171 of the Planning Act in that regard. Now, I mentioned time limits. These are summary offences. In the Magistrates' Court, generally they're summary offences, and that's what summary means before a magistrate in a Magistrates' Court, as opposed to indictable offences, which are generally those commenced by indictment in a higher court. For summary offences under the Planning Act, there are time periods. Have a look at Section 174 of the Planning Act. Also have a look at Section 176 of the Planning Act. Now, it may be that you proceed in the Planning and Environment Court. Have a look at Section 180 of the Planning Act, and it says that a party may commence proceedings in the P&E Court for an enforcement order. So if you like, that Section 180 is the counterpart of 601 of the old Sustainable Planning Act. So the same principles apply whether you're dealing with the Planning Act or the Planning and Sustainable Planning Act earlier before it. It's just that the section numbers and some of the procedures change slightly. But what is common, so you need to look at Section 180 of the Planning Act. You'd also need to consider Section 181, which is where the P&E Court has power to make enforcement orders or interim enforcement orders, and that can do so whether the development offence has been prosecuted or not. So the development offence is in the Magistrates' Court, the enforcement proceedings, the enforcement order is in the Planning and Environment Court. Again, remember that the Magistrates Court does not have an inherent jurisdiction to make equitable orders, whereas the Planning and Environment Court and the District Court, Supreme Court do. Remember also, when you're answering a question of this nature, I'm always keen to see that you have considered ADR process. It's built into the statute, the process, so it's important. And also in that context, to look at practice directions. Do you all know how to access practice directions? Yeah, I mean, you can Google it, but yes, says Sarah, good. They're pretty easy to find. So relevant to this case, you would look at practice direction number 2 of 2009 of the Planning and Environment Court, and I'm sure that we looked at that last week. So revise your notes from last week in that regard. Because practice direction 2 deals with the power of the ADR registrar to make orders or issue directions pursuant to the Planning Act, and also pursuant to Rule 19 of the Planning and Environment Court Rules of 2010. Just a little trick here. When it comes to the Planning and Environment Court, thank you, Sarah, put up the link. When it comes to the Planning and Environment Court, remember, of course, it has its own act, it has its own practice directions, therefore, logically, it has its own rules, and the P&E Court Rules 2010 are, if you like, the counterpart of the UCPR, the Uniform Civil Procedure Rules. There is a crossover, but essentially, you don't want to quote the UCPR as your authority for a rule in a P&E dispute when we have specific P&E court rules. Does that make sense? All right, good. Now, in this instance, the court might, the council rather, might take an alternate approach. I mentioned earlier the Environmental Protection Agency. So the council could rely on the Environmental Protection Act 1994, have a look at sections 14, which provides for environmental harm, and look at section 15 that deals with environmental nuisance. So if you're looking at compliance issues from the perspective of, say, the council, you can look at it from the perspective of criminality, seeking to enforce the conditions, or perhaps relying on the Environmental Protection Act, arguing that what has happened amounts to environmental harm or environmental nuisance. So all of these things occur, but if there is sufficient evidence to justify the prosecution under either of those sections under the EPA, the council should really refer the matter to the state government, which is the far more appropriate prosecuting authority than the council under that section. I know I'm moving fast, but I'm sure you're keeping up. Now, I mentioned earlier the Planning and Environment Court rules, that's P&E Court Rules 210, and some specific rules that you might consider beyond what I've already mentioned. There's Rule 6, which deals with filing an original application. Rule 9, which deals with the originating application to provide certain details. Rule 19, which deals with orders or directions. Rule 25, that deals with ADR. And Rule 30, which provides that experts must prepare a statement of evidence. Did you catch all that? All good? So just quickly again, P&E rules, Rules 6, 9, 19, 25, 30. I mentioned the P&E Court practice directions. Do have a look at those, particularly Practice Direction 1 of 2019, and as I mentioned earlier, Practice Direction 2 of 2019. It's like listening to the lottery numbers, says Sarah. It is a bit, isn't it? And you can tell I'm not a bingo host because I'm not using any of the flowery terms that go with it. Whenever you're considering a case, you need to consider, well, who's the party that bears the onus and what is the burden of proof? So the general rule is if you bring a complaint, it's up to you to prove it, so you have the burden of proving the case. So if you're advising the council, you'd say to the council officers, you're going to have to adduce evidence sufficient to justify your position. What that means is that you probably need expert reports to talk about the inspection of the road, compare it with appropriate standards, determine whether or not on the evidence it's consistent with the approval conditions, etc. And the general rule is that you bring in experts to do that. Provide advice, provide reports. If there are experts on both sides, probably to participate in an experts conclave in conjunction with the P&E registrar, and then of course to provide evidence and submit themselves to cross-examination. That's basically the role of the experts in P&E matters. So of course you then ask the counsel to obtain other evidence such as from neighbours or other things that might be useful. The other thing that might be relevant is this. You'll need to make a call as to whether the prosecuting authority needs to establish the case on the balance of probabilities, which is a civil standard, or beyond reasonable doubt, which is the criminal standard, depending on the type of litigation involved. But remember, of course, that when it's the civil standard, depending on the gravity of the consequences of the offending behaviour, even though it's a civil proceeding, the Brigginshaw test may apply. And what that means is that even though the standard of proof remains on the balance of probabilities, the court will require sufficient evidence to warrant making the order. So it's got to be good quality evidence, even though the test is still on the balance of probabilities. Now, if the counsel applies for interim injunctions, remember, of course, the issues that we discussed last week about the balance of convenience and undertaking as to damages that might be considered. We did talk about that last week, didn't we? I'm taking 2 units this term. Maybe I talked about that in remedies for contract. But when you're seeking an injunction, the general rules apply. Injunction, yes. Damages, no. So if you're seeking an injunction, you need to establish a prima facie case. You need to establish the balance of convenience, and undertaking as to damages may be relevant. All right. If you look at that material in Byrne Brothers on the website, you'll see in the application exactly what it is that the lawyers for the council had drafted, and it was basically a statement that the council applies to the P&E court for an enforcement order pursuant to section 180 of the Act. Well, this would be in the case of the Planning Act. If you're looking at it from the Planning Act, you're seeking an enforcement order requiring the respondents to do certain things by way of undertaking. You're probably going to ask for costs of the investigation and costs of the proceedings and any other orders that the court sees fit. And then you'd normally supplement that by saying, here are the key facts, here are the material facts that the court should consider in making its order. All right, I've talked a lot. You've been very patient, as always. Thank you very much. I'm shortly going to talk just in general terms about the take-home paper, which means that that's the last of the substantive content for the unit. Before I wrap up with the general discussion, are there any questions, comments? All good? Fine? Okay. If you think of something, just let us know. So by now, I'm sure you've all seen my little video on level 3 preparation. So you've taken that on board. And in the next few days, before I release the paper, you're ready to go on that point. In terms of examination writing guide, remember, of course, that you need to use formal language. It needs to be of a certain quality in terms of the writing. You know that I want you to use the active voice where possible. Please try to ensure that at least your opening paragraph is eye-catching. Sarah's corrected me. Did I say you've got a few days before the take-home paper? It's a little over, it's a couple of days, is it? 1 day and 3/4 or something. Before composing, you need to ensure that you have taken time to obtain good materials ready to access the unit and provide the material. Do try to answer logically so that I can follow the flow, and don't repeat the question. You're just wasting space if you do that, but you can incorporate aspects of the question in your answer so that it flows naturally and it is able to be read in isolation without having to necessarily read the paper is always a good idea, but don't just repeat the question. Full AGCL for referencing is required. Yes, please, as is normal. I think you're all pretty much on top of that. If you're not right on top of footnote referencing and AGLC4, please take some time before the take-home paper to find a good way of referring to the material, a good guide for you. Look, run a spelling and grammar test through the exam, proofread, maybe silently read each word, things of that nature, or read it out aloud if you like. For those of you that have provided feedback, thank you very much. I appreciate it. It's very important to the university. It's particularly important to me. So please do take some time to provide feedback if you haven't already. Who knows? Maybe if I finish early, I can give you some time to provide the feedback right now before you go on and start your final study for the unit. So seeing that's such a good idea to finish early, I think we will. So are there any questions, comments, any other issues that you want to raise? All good? Yes, Karen.
Totally away from anything we've talked about tonight, I came across a documentary on SBS over the weekend that was actually really, really good, called Cultivating Murder, which was actually a state environment officer was shot dead by a farmer in New South Wales. And it was all over land clearing, well, illegal land clearing. And it was only
I remember that case.
Really, really interesting, and I'm sure it could be found on SBS Catch Up or whatever they call it.
Thank you for that tip. All right, everyone is ready to go and watch that show. So thank you, Karen. Any other questions, comments? All good? All right. Well, thank you very much. That brings us to the end of the unit. I really appreciate your participation in the unit. Thank you for your involvement. Good luck on Thursday it is Thursday, isn't it, when I release the paper, and have those results in by Friday evening. I'll try to release the paper just a little early, but if I'm a little late, please excuse me, but I will try to get that done on time. Okay, all the best. We'll see you next time. Bye then.